In this video, we're going to continue talking about the circumstances in which a constructive trust arises, and specifically we're going to be talking about mutual wills. So, constructive trust can arise from mutual wills if two or more agree to make wills and not to revoke without mutual consent. So, it's a little bit like creating a contract. The doctrine of mutual wills applies to wills created by two or more people in a particular form with the intention that the provisions of those wills shall be irrevocably binding. Ordinarily, a will would be capable of amendment or repeal. Mutual wills are subtly different because the parties intend that their wills will be binding. If the first to perform dies, then it will be unconscionable for the second to deviate from its terms. In other words, if the first to die didn't change their will before they died, then it would be unconscionable for the second person to change their will later. So, when the first of the parties to the mutual will dies, the agreement becomes binding on any surviving parties. In the event that any survivor should have attempted to change her will or to break the mutual will agreement, her personal representatives after her death would be required to hold her estate as constructive trustees subject to the terms of the mutual wills. So on this model, the essence of the doctrine is the prevention of a fraud being committed by the survivor in failing to comply with the terms of the mutual will agreement. However, it is not necessary that the parties should be beneficiaries of the other party's will, or that they should agree to leave property to the same person or persons. So, in these mutual wills, it is not necessary they leave everything to each other. They are simply just agreeing where to give or put their property. Following the death of the first party, the second party must hold the property on a constructive trust. A mutual will arrangement takes effect by means of a constructive trust, in that the arrangement between the two testators, by reference to which neither of them alters their will, operates on the conscience of the surviving testator once the arrangement has been made, as the Court of Appeal did confirm in the case of Ollins and Walters from 2009. The essential characteristic of mutual wills is that there will be an agreement between the parties not to revoke their wills. So we must see that the parties actually intended this to survive themselves. In other words, they intended that when the first person dies, the second follows through with their will. So we need to see this intention. This agreement must amount to a clear contract in law, so a mutual will arrangement is dependent on there being clear and satisfactory evidence of a contract between two testators to the effect that each of them would make wills in a particular form and that neither party would revoke that will without informing the other testator. And their conduct must infer an agreement, so the conduct of the parties post-will may imply they meant there to be a mutual will. And if you intend to create a mutual will, it should be cited in the will. So if you actually intend for it to be a mutual will, then it's important and it's pretty helpful if you actually mention that it is a mutual will within the will itself. But the problem with mutual wills is that when one individual dies and then the survivor says that they want to change the will, can they actually do this? Or do we impose a constructive trust on them which doesn't allow them to do it? Well, the answer is if you meet all the elements of a mutual will, then it will be a constructive trust and you cannot change any of the elements. In other words, you hold the remaining of your property as a constructive trust. And we got this case of Oldham from 1925. So in this case, a husband and wife made mutual wills, and there was no mention in the will of irrevocability of intention. So the will was absent of any longevity and long-term binding intention of the mutual will. So the husband then dies and the wife remarries. And the first to die, the first to die was the husband. And the question is, what do we do here with respect to the mutual wills? Okay. Now the wife here actually made a new will, which was different from the earlier one. And the court said that the fact that two wills were made in identical terms does not necessarily connote any agreement beyond that of so making them. There is no evidence that there was an agreement that the trust in the mutual will should in all circumstances be irrevocable. They must have thought it is safe to trust the other, but that is very different than saying that they bound themselves by a trust, okay? And that was said by Asprey in the case. So what Asprey is really saying here is that we really need to see that the agreement and intention behind the mutual agreement will go beyond the death itself. So the second will with the new husband was upheld in this case. And we've also got the case of Cleaver from 1981. And, in this case, it was slightly different. The evidence of a mutual will was sufficient. So in this case, an elderly couple married in 1967, and the husband had 3 children. They made wills in each other's favour, absolutely, and default to these 3 children. In 1974, each of them reduced the share of one daughter, Martha, to a life interest. After the husband's death, the wife made a new will consistent with the earlier one. Thereafter, she made a further will, enlarging Martha's share from a life interest to an absolute interest, and by her last will, she left her residue to Martha and her husband and nothing to the other 2 children. It was held that the wife's executors held the estate on the trust of the 1974 will. Sufficient evidence of an agreement to make mutual wills was shown by the similarity of the original wills, the pattern of successive wills made together, the fact that both parties reduced Martha's interest, the faithful terms of the first will made after the first husband's death, and the fact that in family conversations the wife had regarded herself as under an obligation to leave her estate to the children. Okay, so let's look at some of the remedies. So what happens when, one of the parties doesn't uphold the mutual wills? So we've got the regular contract remedies of damages. So your remedies are these basic contractual remedies, and the agreement is binding between the parties. If it is broken by the first person to die, his estate will be liable in damages to the survivor, but not where the revocation of this first will, is by the subsequent marriage of the covenanter. If the breach is by the second party to die, as by revocation or alteration of his will, it has always been assumed that no remedy could be attained against him or his estate under contract. The law which has developed on the subject is based upon a trust which arises in appropriate cases in favour of the beneficiaries. Now, until recently, there could have been no question of the beneficiary suing in contract because of the privity doctrine. But it may now be possible for the beneficiary to enforce the contract in his own right under the Contracts, Rights of Third Parties Act 1999 in the case of contracts between 2 testators made after the Act. The Act does not affect the rights or remedies of third parties which are otherwise available, thus the trust solution does remain too. So that's under Section 7 of the Contracts, Rights of Third Parties Act 1999. Nevertheless, there are a number of difficult situations that arise concerning the operation of such trusts, and there are 3 questions that I want to very quickly look at. So the first is, when does the trust arise? Secondly, to what property does the trust attach? And thirdly, the survivor as a trustee. So firstly, when does a mutual wills trust arise? There are 3 possibilities. So it has been said that there are 3 possibilities as to when the constructive trust arises: when the agreement was made, when the first testator dies, and when the survivor dies. So firstly, when the agreement was made, in other words, when they sign the wills. It is clear that no trust exists from the date of the agreement. This is because either party can revoke or alter his will before either dies on giving notice to the other. And even then, notice isn't necessary in the case of the first to die, for the survivor has notice on the first death and will not be prejudiced. So the survivor in such circumstances is unable to establish any trust in his favour against the estate of the first to die. Secondly, when the first testator dies. So normally the mutual wills trust will arise when the first testator dies. So this is really when the constructive trust begins, thus creating a constructive trustee. So of these 3 possibilities, it seems therefore that the trust arises on the death, without having revoked his will, of the first to die. And thirdly, when the survivor dies. So nor can the death of the survivor be the correct time. For where a beneficiary died between the date of the death of the first to die and the survivor, the estate of that beneficiary was able to claim its share on the ground that the interest was vested and there was no lapse. We have this quote here from Pereira, where Lord Camden said, "He that dies first does by his death carry the agreement on his part into execution. If the other refuses, he is guilty of a fraud, can never unbind himself and become a trustee of course, for no man shall deceive another to his prejudice." So he was very adamant that if you make this agreement, you intend to be bound, and then if one person dies, the other person cannot then change their mind, as this would be disrespecting the former individual. The second question is, to what property does the trust attach? Now, this may be clear from the express trust of the will, as was the case of Green from 1951, but failing that and subject to a contrary intention, there are four possibilities that the trust attaches to the property, if any, when the survivor receives from the estate of the first to die, or to all the property that the survivor owned at that time, or to all the property which the survivor owned at his death, or to all property which the survivor owned at any time since the death of the first. So let's look at these in turn. So firstly, property which the survivor receives at the first death. So in this scenario, the first person dies. Their will says some property will go to X and some property will go to Y. The question is it that particular property coming from the individual that has died that the trust attaches? Clearly, the trust must include any property received from the first to die. Okay. So, secondly, is it all the property that the survivor owns at the time of the first death? So in this scenario, the first person dies and the property under their will is distributed. Then is the trust property here everything that the survivor owns at that moment? Now, Rehager from 1930 suggests that the trust attaches at least to all the property which the survivor had at the time of the first death. Okay. Thirdly, property owned at the death of the survivor. So when both of them have died, is it that property that exists at that time that is to be held on a constructive trust? Morritt has held that the trust embraced the survivor's whole estate at his or her death. So this means that a lifetime disposition by a survivor would be a breach of trust. Indeed, it would make nonsense of the trust if he could so dispose of that property. And fourthly, all property owned at any time by the survivor since the death of the first. So is it that the first one dies and then for the remainder of the survivor's life, all the property they own during that period of time is the property over which the constructive trust operates? If this is correct, the effect of the mutual wills is to reduce the survivor to the position of a life tenant in respect of all of his property. He may use the income, but the capital is held on trust for the ultimate beneficiaries. Now, there is no definite answer to the question of which property precisely the trust attaches. The best thing to do, really, is to expressly say what property you're on about expressly in the will. And now we got this quote here from Cleaver in 1981. "I see no difficulty in modern equity attaching such assets a constructive trust which allow the survivor to enjoy the property subject to a fiduciary duty which, so to speak, crystallised on his death and disabled him only from making voluntary dispositions inter vivos." So Justice North here is saying that once the first person dies, the property the survivor gets is the property that must be held on a constructive trust. The third question is the survivor as trustee. So let's think about this. You own a bunch of property with your wife. You create these mutual wills saying that you'll do certain things with the property intending to be bound. One of you then dies and the other becomes the constructive trustee for the property. What does this actually mean? Where is the legal, proprietary, equitable title? So what title does the trustee hold? They hold the the legal title, whereas the equitable title, well, that's with the beneficiary. So, this is the problem. As soon as the first one dies, the second surviving person loses their equitable interest in their property. So they now have duties and responsibilities to hold that property for the benefit of someone else. So, they won't be able to sell their house, sell their goods, gamble their money away, and so on and so forth. So you can really see the complication of this. And if it is correct that the survivor becomes a trustee of all the property he owns or acquires before his death, the consequences of the doctrine could be draconian for the survivor. It is clear that the imposition by law of a trust in cases of mutual wills is a clumsy and inadequate way of dealing with a complicated problem. A contractual solution under the Beswick principle would be much more satisfactory, but this has not been accepted. A solution based on the idea of a floating charge has also been suggested, although this does not solve the problem that the beneficiaries are often, unaware of the situation. For the present, persons who wish to leave property by way of mutual will should be advised to consider most carefully the trusts on which they wish the property to be held, what property is to be included, the position during the survivor's lifetime, who they wish to be trustees, what administrative powers the trustee should have, and how best the scheme desired can be carried out from an inheritance tax point of view. So merely to draft mutual wills and then leave the law to sort out such a host of problems is no service to the testator. The law in this context, as in most areas of constructive trusts, imposes a trust in an attempt to prevent one party from committing a fraud on the other, and it's a kind of salvage operation, a salvage of a wreck which competent legal advice would have avoided in the first place. The recently expressed view in the Court of Appeal from the case of Walter and Oylands from 2008 is that the mutual wills doctrine continues to be a source of contention for the families of those who have invoked it. The likelihood is that in future, even fewer people will opt for such an arrangement, and even more will be warned against the risks involved. Okay, that is the end of this discussion on mutual wills, and I hope you've understood it, but as always, if you have any questions, then please do leave them below this video. In the next video, we're going to continue talking about the different circumstances in which constructive trusts arise, and particularly talking about the circumstance of when it arises in a land context. Anyway, I hope you enjoyed the video, and if you enjoyed it, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.